and I'm the incoming communications director for the Senate Minority. And my role here today is really just to facilitate a conversation and opportunity for information sharing around some of the issues regarding the judiciary that we anticipate this session. I'm going to do some introductions, and then I'm going to pass it to our speakers, and we're going to go right down this line, each of you one right after another, and then have some time for questions at the end. I may end up moving the mic to you for questions as a way to just keep this moving and get as much information to the people as we can. So first off, we have Laura Smith. Laura is joining the Senate as Minority Whip this session. She's an attorney, and prior to being a legislator, Laura clerked for the Montana Supreme Court and served as Assistant United States Attorney prosecuting violent crime and fraud all across Montana. We also have Governor Marc Racicot. He has served as the Attorney General and former Governor of Montana and Chairman of the Republican National Committee. He has navigated the court system from many angles and sees the need for bipartisan support on keeping the courts impartial. Jim Reynolds was a first Judicial District Court judge from 2011 until his retirement in 2020. While serving on the bench, he took his oath of office very seriously, and his high retention rate during his tenure as a judge is proof of his success in carrying out his duties impartially. We also have James Reavis. James served as a public defender for 11 years for the state of Montana and now represents defendants in federal court as part of his private practice.
Reavis has appeared in city courts, district courts, and the Montana Supreme Court. He is a newly elected representative from Billings, which has the busiest court docket in the state. And now I'll pass it off to Laura.
All right, thank you very much, Erin. So we are here today because our Montana courts are under attack. There have been dozens of bill proposals already discussed and drafted that undermine our court system and starve us as Montanans of our freedoms under the Montana Constitution. This includes things like the right to privacy, and I think this is something that all Montanans hold very dear. I think about it in relation to reproductive health, and that right to privacy ensures there's no politician in your doctor's office. This also includes our right to vote. It's a constitutional right that I think many of us hold dear. It means that there is no one standing between you and the voting booth. And I also think the right to a fair shake in court. We all want a fair shake if we find ourselves in court. And these are just a few of the rights that the Montana Supreme Court has upheld in recent years. During the past 2 legislative cycles, the legislature has knowingly passed unconstitutional legislation. These efforts threaten the rights of every single Montanan in our state. They're a waste of time, and they cost taxpayer money. And just on a personal note, I knocked thousands of doors campaigning this last cycle, and I will tell you, our constituents have the right to ensure that their taxpayer money is being used with integrity. And now what we have is a small group of individuals pointing their fingers at the court for doing its job, upholding your individual rights under the Constitution. The efforts underway are designed to dismantle our court system and insert narrow political agendas at the expense of Montana's impartial courts. This has created a hostile situation, frankly, for nonpartisan judges who swore an oath to protect our rights under the Constitution and help Montanans with everyday legal issues that keep our communities and families moving forward. There's even more legislation currently being drafted that will attack the constitutional rights of every Montanan and your individual right to a fair and impartial justice before any Montana court across our state. And I will tell you from a personal perspective, I have heard over and over and over from individuals that I have talked to in our community that they are absolutely tired of political fighting and they want fewer politics in their lives, not more. These proposals are also out of touch with our longstanding tradition of fair and impartial courts since our nation's founding. And we really only recently became aware of the scope of these extreme political intentions. And so I'd like to thank our nonpartisan judicial experts who are able to attend and provide their perspective on the impact of this harmful legislation. And I'll tell you this, the solution is very clear. Each one of us must come together to protect our constitutional rights that are guaranteed in our Montana Constitution. We expect that individual legislators will do our jobs so that laws that clearly violate our constitutional rights and our Constitution do not get out of this building. And if they do end up in court, we must respect the court, an American institution that has effectively safeguarded our rights for hundreds of years, to let them continue to do their jobs fairly and impartially. Thank you very much. I would next like to introduce Governor Racicot.
Thank you, Laura, and good morning. Happy to be with all of you. Let me get to the point quickly so that we can, which is contrary to my normal inclinations, so we can get to questions and some cross-examination that you think might be appropriate this morning. Let me begin by taking note of the fact that the Montana Constitution, as does the United States Constitution, carefully and very explicitly allocates the political power of the government among three distinct branches. We've all heard that principle articulated in our growing up years and frequently in these halls over the last few years. Now, that allocation of power is the means of establishing stability and balance and a certain dynamic tension that prevents the arbitrary exercise of power and the encroachment of one branch usurping the authority of another. The separation of powers and the rule of law embodied in our constitutions are unequivocally indispensable to the life of a democratic republic. In Alexander Hamilton's words, there can be no liberty if the power of judging is not clearly and completely separated from the legislative and executive functions. Having neither the power of the purse or the sword, as he mentioned, a free people cannot and they will not exist without the complete independence of the judiciary. In equal measure, the allocation of political authority is intended to protect and preserve the permanent institutions of the state and the nation from, among other things, an unrelenting effort by one faction to exercise complete control over another, thereby threatening the demise of democracy and ultimately our way of life. Apparently, as we consider the present-day circumstances, protecting and preserving the independence and impartiality of the judiciary required by the law and our constitutions cannot compete with the extreme impulse of some members of the legislature and their allies to control all three branches of state government, thereby ignoring their oath of office and dismissing the express promise they made to support, protect, and defend the Constitution of the United States and the state of Montana. Every legislative member is required to take an oath of office that promises to, quote, protect, support, and defend the Constitution of Montana and the Constitution of the United States of America, and to do so with an immutable commitment to discharge his or her duties faithfully, with fidelity, as the oath articulates. It is a solemn promise that we're talking about here that unconditionally binds legislators to the rule of law. The oath demands a transcendent loyalty, not to a political party, not to a faction of one kind or another, but instead reflects a sacred vow to act in every instance and above all else in the interest of the public good. These proposals that have been discussed, not completely yet in my understanding, articulated in every respect, are simply extremist measures offered for the convenience and for the ultimate satisfaction of individual groups within the legislature. As a consequence of that, we intend to make certain that our fellow citizens understand and know everything there is to know about these proposals in an effort to make sure that we safeguard our Constitution and ultimately the peace and well-being of the state of Montana. Thank you. It's my privilege to introduce the distinguished jurist to my right, Judge Jim Reynolds.
Wow, Aaron, this is just like the good old days for me. I think you were all supposed to stand up when I came over here, but this time I'll let you just stay seated. This time I'll let you do that. Anyway, as I was introduced, my name is Jim Reynolds, and I was a district judge here in the Lewis and Clark First Judicial District from 2011 until 2020. I don't know that people really know the scope of what we did as district judges. When I retired in 2020, I started off in a brand new district. There had never been a judge in this particular department before. The 2009 legislature had approved the funds to create this new department, so I had never run for political office before, never thought about running for political office before, but I thought I'm going to give it a shot. I'll go ahead and run for that office. There were 5 of us that ran. I won the primary, advanced to the general election. I won the general election by a landslide. According to Donald Trump's description of a landslide, I got 51% of the vote. So it was really close election. So I took the oath of office, and as Governor Racicot has mentioned, I took an oath of office to uphold and protect the Constitution of the United States and the Constitution of the state of Montana. I did not ever seek, nor did I accept any endorsement from any political party in my election. I did not swear an oath to uphold the Republican Party or to uphold the Democratic Party platform. I had my own platform. It was developed from my 30 years of experience as a lawyer in the district, plus talking to people on the campaign trail. It had 3 components. Nobody consulted with any political party in developing these 3 components. I wanted to set up a treatment court, a drug treatment court, to help people whose drug addiction had gotten them in trouble. I wanted to deal with the situation down in Broadwater County where there was confusion over which judge was going to be handling that. I was going to become the Broadwater County judge. And third, as a matter of philosophy, and somewhat arrogantly, I think, I was going to be a people's court. I was going to be a place where people could bring their disputes and have them adjudged impartially on their merits without consideration of their race, their religion, their sex, their disability, their age, or their political party. I had no intention at all of considering any of those things. In 30 years of practice, I had never considered any of those things in deciding whether I was going to take on a case or not. That wasn't going to be part of my mix in my courtroom. And I am proud to say that when I ran for retention after 6 years, like I said, that first one, real close. It was a hard-fought race. I got 51%. When I ran for retention, no one ran against me after 6 years. I got over 85% positive vote. That was the highest retention vote of any of the judges that were up for retention that year. I'm very proud of that, because again, I'm a nice guy, but I'm a pretty arrogant guy too. I interpreted that as the citizens of the First Judicial District telling me I'm doing it right. I was doing it right. I wasn't paying attention to political expediency or what was the flavor of the day. I was doing it right. Most cases that I dealt with, and I had over 900 cases when I left the bench, 900 open cases. Most of those cases I dealt with over those 10 years had no political meaning to them. It was somebody fighting over a parenting plan, someone fighting over a divorce, someone fighting over an easement. There was no political component to any of those. Now, a handful did have a political component. Those were difficult to deal with. I was called upon to decide whether our Supreme Court justices should be elected from regions instead of statewide. There had been a law passed by the 2009 legislature that said Supreme Court justices each would be elected from a district within the state, and then those 7 judges would get together and vote on who the Chief Justice was going to be. That came to my court. That's a pretty hot-button political issue. So what I did is I took the Constitution, which I had sworn to uphold, and I literally laid it side by side with this new law. And I compared those 2 documents. This Constitution is what protects our rights, it's what protects our government, it protects us. And this law was passed by the legislature, and it did not fit with what the Constitution said we should use as a means of adopting or electing our Supreme Court justices. I declared that law unconstitutional. And I had no regrets about that. That was the right decision. It was a Constitution. That's the sacred document that we all rely on. We have to rely on. That's the rules of our game, the rules of our state. And that's what I relied on. I wasn't the most popular guy in the world among certain elements of the electorate, but I got 85% of the popular vote. So I firmly reject the idea that we need to intrude political considerations into the legislature. We just don't need to do that. When you're a judge, you're up there, you're so busy trying to figure out what the heck you're going to do with this kid in this custody case or this easement case. You're just trying to figure out what to do with these cases. Imposing a political view on that, we don't have time for it. We don't have time for it, and it's wrong. We've not done it in 200 years in the country. We have not done it in the entire statehood of Montana. We don't need to do it. So, thank you.
My name is James Reavis, and I served as a public defender for 11 years. And in that course of time, as a public defender, you represent clients that are in a tough spot. They've been accused of a very serious crime. Their parental rights are at stake. They may be facing commitment to the Montana State Hospital and having their lives overturned. I represented hundreds of these individuals. And for 99% of those clients, I had no idea what their politics were because it wasn't relevant to the facts of the case. It was about what have you been accused of or what's the situation? What is the law that applies? How is this affecting your life? What can we do to get you through this court system, to get you in a better position out on the other side? I can't imagine how tragic it would be after learning about the client's life and their dreams and their family and what they want to do after they get through this court system process, if I then had to ask, oh, wait a minute, I've got another question for you. What are your politics? Oh, what are the judges' politics? How are we going to have to take these things into consideration? That's something awful. That is not the conversation that I want to be having with my clients. We have got to keep politics out of the courtroom. Really being a public defender gave me a lot of faith in the people because it really showed that politics isn't the controlling thing in our lives. It's our family, it's our jobs, it's the connections that we have with each other. And we really have a beautiful thing in Montana with these fair and impartial courts. And frankly, other states in this country have lost those. It's a beautiful thing, and I don't want to lose it. And these dangerous, extreme bills that are being proposed, once you start dipping that pen into this well, you can't undo it. And And we really have to be at the front and at the vanguard of protecting our fair and impartial courts and upholding the values in Montana's Constitution. Montanans don't want this. Montanans don't even want to be in court, right? When you come to court, it's usually not for a great reason in the first place. Can you imagine already having to be hauled into court and then being asked, oh, now we have to have a political litmus test. Uh-oh, we have to think about if the judge is a Democrat or if the judge is a Republican. That's not a future for Montana that I want, and I don't think it's a future that Montanans want. But these bills aren't law yet. I would implore the people who are listening to this, contact your local legislator. Tell them, I want to keep politics out of the courtroom. I want to have fair and impartial courts. And I think that's all I've got to say. Aaron, I'll turn it back to you.
Well, I think my introduction fell short in gratitude. I want to thank you all for your remarks, for showing up today on a relatively short notice after the holiday. And yeah, we have quite a bit of time for questions. So I think depending on the question, we have a sense for multiple people that might be interested in responding. So we'll open that up. If you just want to raise your hand, introduce yourself, ask your question. Would it help if I repeated the question? Yes, okay, I'm getting some nods, and then we'll pass it along to those who are interested in answering. Sure.
Seaborn Larson from the Lee newspapers here. And I guess we did see this kind of rhetoric against the courts last session as well. And in the last election cycle, many of those people were reelected. The legislature still holds a majority in the with Republicans, and the governor's office remains Republican. I guess I'm wondering how you see voters kind of weighing in on how Republicans are approaching the courts these days, if they continue to elect Republicans in that way.
Start with Laura, and then Marc might have some thoughts. Oh,
The mic is coming to us.
yeah.
I will start by saying it really stood out to me what Governor Racicot said about the importance of voters knowing what is happening. My guess is most folks in their busy lives don't realize some of the votes that are being made to turn the courts political right before their eyes. And so I think there's a lot to be said for this conversation to ensure that people know what's happening up at the Capitol. People are busy. And I will tell you, again, talking to thousands of Montanans in the course of the last several years, going through 2 campaign cycles, people want a fair shake in front of their courts. They're not interested in having politics injected into their courts. They just want a fair and impartial decision made. And again, the decisions, as has been reiterated by Representative Reavis, these are, and Judge Reynolds, these matters in courts are and should be distinctly non-political. We're talking about family law issues, we're talking about easements, and I'll tell you, as a former prosecutor and as someone who understands the variety of matters that come before courts, people don't want politics in these decisions. They want decisions made by a fair and impartial judge who will look at the facts and apply them to the law. And I think it's one of the most important responsibilities in institutions in our community for fair and impartial decision making.
I would begin by taking note of the fact that we have some history indicating certain, I think, trends among the people we live with as our fellow citizens. First of all, I have found them always to be inclined to open discussion about a variety of different issues, and particularly, I think we learned from the last session when there were 69 different proposals that were made to the legislature that had to do in some fashion with the Constitution of Montana and with the judiciary in Montana. 15 of those were ultimately introduced, and none of them passed. So that, I think, reflected to me that there is a process of osmosis, not as fast as we would like it to be, that gradually invades the minds and hearts and consciences of all of us in the country and in this state. And there's accumulated knowledge that has something to do with how Montanans, I think, this time will look at these issues. So that's one marker that I think indicates that this is still a very, very relevant and strong issue in the minds of our fellow citizens. Secondly, I would point out that in my discussions with members of both parties over the last several months and during the last legislative session, many of them who may have ultimately voted for some of those proposals didn't believe it either. They knew something was wrong. And I think all of us can sense in the country and in this state that there's a lack of a same kind of stable rhythm of life that we once all experienced. And I think part of that, it can be blamed upon the notion that you can just tinker at will, like a board game, with the Constitution of the state of Montana and expect that all of our affairs will continue to unfold in a way that's thoughtful, dispassionate, and just. Once you start picking apart provisions of the Constitution and tinkering with the judiciary in an effort to try and secure your own point of view, which typically never works anyway, I think you get to the point rather quickly to conclude that this is not for the state of Montana. And these efforts to control, you know, when you think about our human nature, we're always trying to control something. I mean, whether it's a marriage or a child-parent relationship, whatever it might be, control is one of those instincts that probably related to competition that we tend to get engaged with easily. So this formula does not suggest good things for the state of Montana, where you have people dangerously trying to pick apart the Constitution, ignoring the independence and faithfulness of the judiciary, trying to bring it under the control of the legislature because they don't do precisely what the legislature wants done. The legislature revealing thereby a lack of trust in the people they actually serve to make the right decisions for the right reasons. So this is an audience we think is very open to thoughtful argument, as are the legislators that will be considering this. They're not fools. They are adhering, of course, to this, whatever it is, amalgam that holds them all together at the end of the day, this herd mentality. But they, too, during the last session, some of them revealed some independence that reflected sound judgment. And so we think we have a very, very capable audience of making very thoughtful decisions, but we have to be involved daily, constantly, in talking about these issues in a civil fashion, ultimately hoping for them to make a sound judgment.
Governor Racicot, but I have kind of a weedy question about strategy heading into the next session. So, in talking about stopping these bills that you want to stop that would affect the judiciary, I wonder what that strategy looks like when session comes, especially when I know the Democratic caucus has been trying to figure out its footing on this issue. For example, not participating in the Judicial Accountability Committee. I do wonder if there are times Democratic votes might have swayed decisions one way or the other. We've seen Republicans split in that committee at various times. I know Democrats didn't want to legitimize that committee, didn't want to participate in it, but then I do wonder, how do you come back to it this session? What does that look like in a strategy sense?
Yeah, thank you for that question. I will start by saying that I think many people in the room were able to see the charter that was developed for this group, and it was extremely clear that the intent was not to improve any processes, but to actually undermine the courts. It is not our jobs, as others have said, to undermine the courts. It is our job to uphold our Constitution and do the will of the people, so we did not participate. What I will say going into the session is that this conversation actually came about because various individuals had been talking with us about their deep concern of this high number of bills that really are intended to inject one branch's politics into another and really impact the systems that are working, right? You've got a fair and impartial judiciary. To answer the second part of your question about strategy, we have been hearing from various groups, and I'll tell you, they're not partisan, right? That's been the interesting thing. The individuals and the groups that are really seeing what's happening with these bills, and it's happened very quickly, right, over the last couple of months, escalated very quickly. These groups are recognizing the impact on everyday individuals and their ability not just to get a fair shake in the courts, but to have an effective judicial system. I mean, without going into sort of details about it, some of these proposals are going to slow down court systems for individuals. Heaven forbid any of us need to end up in a court system or have a case. But it's going to have very everyday impacts on individuals. And as the governor said, we have communities across Montana and individuals across Montana who immediately this raises red flags for. If you're a business owner and you need to go into court, if you're a rancher and you need to go into court, if you have an easement issue and you need to go into court, the last thing you want is a bill that impacts the impartiality of your judge and, frankly, the speed at which you can get a decision. So these are issues that I think more and more individuals across our state are really picking up on and are expressing concern about.
Yes, Jonathan and Mary from Montana Television Network. Obviously, you guys have expressed concerns about all the bills being proposed, talking about the judiciary. I wonder if there are any proposals in particular that you think are particularly objectionable, and if there was anything at all that came out of the committee that's meeting today that you thought was at least worthy of discussion.
You know, I think the most prime example is there is a bill that says judges must run under partisan labels. That is exactly the kind of thing that goes against the fair and impartial courts that Montanans want. We don't want judges running under partisan labels. And these other bills, each of these bills are part of a system that injects politics into the courtroom. And what we have to do is we have to be on a united front saying, Montanans, they care about fair and impartial courts. And we cannot inject politics into the courtroom. And I think all of us here are just saying it is so important. We have such a beautiful, powerful thing in Montana where we make decisions based on the rule of law and what the facts are and what the law is and how we are guided by the Constitution as Judge Reynolds explained. So, yeah, I mean, to give you an example, yeah, there's actually a bill that says let's put partisan labels on judges. I published an editorial on November 24th in the Billings Gazette. There's more details in there on those other proposals. But what's really important to understand is that all of these bills are working in concert to inject politics in the courtroom, and that's not what we want.
As I said, I've never run for political office. And I wasn't going to run for judge, to be honest with you. It was never part of my career plan. I had several people approach me when we had this new department created. I'd been practicing law for 30 years in Helena, and I think they said, let's get rid of him, put him on the bench, get him out of the way, you know. So I finally let myself be persuaded to run. Had I been required, though, to identify myself as a Republican or a Democrat in order to run, I wouldn't have run. I wasn't going to do that. I didn't do that as a private lawyer. I wasn't going to do it as a judge candidate. I did not do it as a judge candidate. I never saw it, nor did I accept any sort of endorsement from any political party or political entity. I was going to run to be a judge that was going to sit up there and listen to cases on their merits impartially and make the best decision I was capable of making. That whole idea of identifying myself as Republican, I've never even told my wife what I am. So I'm not going to do that. And I think there are other judges or other lawyers out there that would have that same attitude.
Well, my wife squeezed it out of me. She made me tell her what I was. Let's think about the reason for the rule. The reason for the rule is independence. And if you do not have independence, then you do not have people who, as human beings, try to ultimately communicate, who are judging things on the basis of their merits. There were two ways in the beginning that the selection of judges was contemplated. One was, of course, that you could elect them. The second one was that you could provide them lifetime tenure. Now, in the federal system, they're subject to lifetime tenure. So once appointed, they stay until the day that they're leaving the courtroom, some of them beyond probably a healthy moment in time. And this is really a poorly disguised dog whistle for how do we get control of virtually everything so we can do everything we want to do our way. And what that reflects is a lack of confidence and trust in the people that you serve, that they can't be trusted to elect judges and to then have a chance to pass on their performance at some later moment in time, 6 or 8 years later, that you can't trust that. You have to make them now go even further and run on a partisan ticket so that we can try to figure out what it is that we need to do in terms of appointing them. And then another bill giving the governor the opportunity to appoint some judges. So it's really a poorly disguised effort to try and seek more and more control. I think that will be something that legislators, regardless of party, can understand. Whether they are so bound to each other, held together by an adhesive that seems to be so unbreakable or not, I think depends upon how much they hear from their fellow citizens about their concerns. So that's really what this is all about. We're not trying to beat up individual legislators or castigate. We're trying to reason with the people who are going to be making the decisions, and we're trying to reason with the people we live with. And we all believe that those people have a very, very profound concern about what's unfolding here and will take it very seriously in making their judgments.
Larry Miller with the Daily Montana. As lawmakers and/or members of the public who are going to come up and testify on some of these bills come, next year, how do you convince the lawmakers and the constituents who aren't on the same page as you, who do want partisan judges, who think all the Supreme Court decisions are wrong? How do you convince them that, some of these bills aren't good, I guess?
Well, we're optimists, eternal optimists, and the Constitution is optimistic. A democracy is optimistic. We believe there's always a possibility of living in freedom and in union with each other while respecting individual rights and thoughts. And yes, there are going to be some recalcitrant members of the legislature. They will not want to hear our discussions. But there are many members that I think in my travels over the last couple of years that I'm convinced will be careful and thoughtful. And especially, at the end of the day, frankly, it's the individual citizens that have concern, that voice it, and that talk with their individual representation to make certain that their views are understood. And hopefully there are some leaders within the legislature, certainly sitting next to one of them, who are capable of making arguments on behalf of those altruistic principles that we want to see preserved and protected. And so I think the emotional cause is on our side. The intellectual cause is on our side. And that we need to stop this, this process of trying to control virtually every aspect of the government. George Washington saw this coming, and that's why he disdained parties, is because he was concerned about them moving into factions and ultimately into tyranny. And those who think that these steps aren't possible in this delicate arrangement that we have living together in a democracy are fools, because at the end of the day, more democracies have failed than have been invented over the course of the last 100 years or so. So it's a profound moment in the history of our state. and we have to be profoundly engaged as individual citizens. Is it an uphill battle? You bet it is. But intellectually, emotionally, we have a cause to be presented to the people we live with, and an optimistic belief that they'll respond to it.
I mean, Blair, to answer your question, I could just imagine, you're a proud Republican, you're wearing a MAGA hat, you get pulled over for a speeding ticket, and now you're before a Democrat judge, right? Like, that's the system. I mean, because that's the system we're going to create if we adopt these bills where we have judges running under partisan labels. It undermines the integrity of the law, because rather than was I speeding or not, and I got punished appropriately, oh, it's not fair because he's a member of a party I disagree with. Or other people think it's fair because the judge is a member of a party I agree with. And so I think it just requires, in terms of persuasion and why there's, I think, we've got members of both parties up on this desk here. And it putting yourself in the other foot, seeing the other perspective on how this thing can get turned around, right? And just understanding that and knowing we want a judiciary that actually looks at things. We don't want the public saying, oh, well, the judge made that decision, but he ran under this partisan label, so I'm going to second guess it. We've got to keep those discussions in the legislature, and we got to let judges do their job.
Hi, Zeke Lloyd, Montana Free Press. I'm curious how far you expect this legislation to actually make it in the session, and if you think it's going to be a hard-fought fight throughout the months coming in January.
I think it's going to be I think it's very definitely going to be a contest that requires endurance, patience, thoughtfulness, research, the opportunity to persuade. So yeah, I think we're prepared to run the marathon, and expect that that's what it's going to be. You know better than I do.
What he said. No, I think you're right. The sheer volume of the bills, right, is striking. I mean, it is a full-on attack on a single branch of our government. What I will say is, so I served in the legislature in the House last session, and prior to that I worked for a state agency, and so I've been through several legislative sessions. And what I will tell you is that our colleagues in the House and the Senate are thoughtful people who will have conversations with us and reason with us about the impact of what these laws will actually do. And so I am hopeful in that regard. And at the same time, the sheer volume and content of these bills is extremely concerning.
Well, I guess just one more round of thank you to our speakers here today, and thank you to everybody who also attended on short notice. And I'm happy to stand around and provide any more additional materials or answer any questions or needs that you have after this. So thank you. Have a great Wednesday.